Okay, fantastic. So I will begin. So starting with a bit of background, the agreement governing activities of states on the moon and other celestial bodies was adopted on the 5th of December, 1979, and entered into force on the 11th of July, 1984. There are now 17 adherents because, as of January of this year, Saudi Arabia officially withdrew from the moon agreement. Amongst these 17 states parties, none of them are major spacefaring nations. The Moon Agreement is the last of the 5 treaties forming the international legal framework and serves to supplement the Outer Space Treaty of 1967. If we turn our attention to the preamble, we see a few things. Firstly, it acknowledges the strides made up to that point in exploration and the benefits that could be derived from exploiting the moon's natural resources. It also recalls the principles of international cooperation and the goals of preventing international conflict as set out in the Outer Space Treaty. Finally, it acknowledges the need to define and develop the provisions of previous international instruments in relation to the moon and other celestial bodies. Next slide, please. So turning to Article 1, this article sets the parameters of the application of the Moon Agreement, and it provides that the Moon Agreement will cover activities on the moon, other celestial bodies within the solar system, insofar as there are no other specific norms that have entered into force to govern these, and orbits around and trajectories to and around the moon. It does not cover extraterrestrial material that reaches the Earth's surface by natural means. One point that authors have underscored is the absence of a definition of celestial bodies. From an astronomical perspective, celestial bodies can take different forms. And so from a legal perspective, we need to determine whether we are going to be discussing all forms of celestial bodies or whether we're going to focus on a few. In that regard, some authors have suggested a distinction based on the whether human exploration is feasible or whether there is a human value. However we choose to go forward, a clear definition is necessary to clarify the scope of the Moon Agreement. Next slide, please. Turning to Article 2, this article provides that all activities on the moon are to be carried out in accordance with the UN Charter, more on that later, and the Declaration, in the interests of promoting international cooperation and maintaining international peace, which echoes the preamble and Article 3 of the Outer Space Treaty, as well as the preamble and Article 1 of the UN Charter, and with due regard to the corresponding interests of states parties. And on this point, I'd like to make 2 subpoints. Firstly, concrete guidance is needed concerning the definition of due regard. Because it's not been clearly defined, it is open to interpretation, and so the diverse perspectives of different states. Once we get clarity on it, we can create a harmonized interpretation that can guide states parties moving forward. The second point I'd like to raise concerns the common heritage issue, which will be discussed later by my colleague. But I'd just like to raise this one question that some authors have pointed out. And this is that if the moon is meant to be the common heritage of all mankind, yet Article 2 limits due regard to the interests of the 17 other states parties, can we truly say that it is the common heritage of all mankind? Next slide, please. Article 3 discusses demilitarization and de-weaponization, and it explicitly provides that the moon is to be used exclusively for peaceful purposes, which echoes the Outer Space Treaty again. It then provides examples, as you can see on the screen, of activities that are prohibited and those that are allowed. One interesting point in Article 3 concerns the prohibition against the use of force. If we recall our earlier discussion on Article 2, that provided that all activities are to be carried out in accordance with the UN Charter. And if we look at the UN Charter, in Articles 42 and 51, they both provide for the use of force. Article 51 describes it as an inherent right of self-defense in the event of an armed attack against a UN member state. And Article 42 provides that the Security Council can authorize the use of force to remove a breach of the peace. Therefore, it would appear that the use of force may be permitted following the UN Charter, even though it is prohibited under Article 3. Next slide, please. Turning to Article 4, this article provides that the exploration and use of the moon shall be the province of all mankind, echoing Article 1 of the Outer Space Treaty. It also recalls the principle of international cooperation and added that this can take place on multilateral and bilateral bases or through international intergovernmental organizations. Here again, we need a definition of the term province of all mankind. Some authors have suggested a distinction between province of all mankind and common heritage of all mankind, suggesting that the province of all mankind focuses on activities. Dr. Frans van der Dam has suggested that the province of all mankind is a form of terra communis, and this means that we're operating or we're departing from the freedom to explore and use, with an additional obligation to not cause significant harm. There is some support for this in Article 4 itself, which says that these activities, the exploration and use of the moon, shall be carried out for the benefit of all countries, and that there should be due regard to future and present generations. But again, clarity is needed to clearly state what this concept is intended to mean. Next slide, please. So Article 5 addresses notification obligations to the SG of the UN, the public, the international scientific community, and it details the type of information that needs to be provided, when that information needs to be provided, and in what contexts. This serves to foster international cooperation and transparency amongst states parties, as well as building that mutual trust and facilitating the benefit sharing that was referenced in Articles 2 and 4 above. So you can go to not the next slide, the slide after that, which would be Article 6. Thank you. Article 7 provides for the freedom of scientific investigation. States parties enjoy a number of rights regarding this freedom of scientific investigation. For example, the right to collect and remove samples of minerals and substances from the moon, the right to retain these samples that they've collected and use them for scientific purposes, etc. States parties are also encouraged to share the scientific personnel and samples in an effort to foster that international cooperation that we've seen throughout the Moon Agreement so far. One challenge that has been pointed out by some authors is that scientific investigation and commercial ventures are inextricably linked. And often, commercial ventures are born out of scientific investigations. So the question that remains is, when does an activity become a commercial venture? Next slide, please. Finally, Article 7 calls for environmental protection. And states parties are called to take a number of steps. For example, measures to prevent the disruption of the existing balance of the environment on the moon as well as on Earth. They also are called to inform the SG of the UN of the measures that they've adopted and notify the SG in advance of placements by them of radioactive materials on the moon, as well as the purposes of these placements. They are also called to report to other states parties and the SG concerning areas of special scientific interest on the moon, so that consideration can be given to designating these areas international scientific preserves, and so that agreement can be arrived at concerning special protective arrangements. And this brings me to the end of my presentation. So thank you very much for your time, and on to the next speaker.